Welcome to our introductory video to the Consumer Guarantees Act. It is important for small and medium-sized enterprises, or SMEs, such as yourself, to understand the Consumer Guarantees Act, commonly known as the CGA. The CGA is legislation with the purpose of protecting consumers. The CGA applies to any supplier who is selling a good or service and consumers who are purchasing these goods or services. This is seen through Section 5 to 15 of the Consumer Guarantees Act, 1993. So what is a consumer? A consumer is any person who acquires from a supplier goods or services of a kind ordinarily acquired for personal, domestic, or household use or consumption. In terms of acquires, this means to obtain by way of gift, purchase, or exchange, and also means take on lease, hire, or hire purchase. For example, a microwave purchased by a consumer for personal use in their home. A consumer can also include companies, not just a person.
What situations do CGA not apply to consumers? Well, in Part 4, Sections 28 to 31 of the CGA, it does not apply if the goods and services are resupplied in trade, goods or services cannot be consumed during the course of production or manufacture, and those goods and services cannot be used to repair other goods or fixtures. Now, under the CGA for consumers, what guarantees are given to them? The goods must be in acceptable appearance and must be completed. No damages or external signs of wear should be seen. The goods should be free from minor defects, even though it is unlikely that it will affect the usability of the product. The goods should obviously be safe for consumers to use, or suppliers could face dire consequences. The goods should have a decent amount of durability, and it should fit the purpose for which the goods of that type are commonly supplied. The CGA's acceptable quality trait is not breached if the consumers are told beforehand of possible defects in the goods supplied. It is also assumed that consumers should not be inappropriately using the product for their unintended use. However, if a consumer made their purposes known to the supplier beforehand, the supplier must meet those purposes unless they're not relying on the supplier's skill or judgment. The goods must comply with the description, goods must comply with sample, and the manufacturer should honor express their guarantees. But what if the goods are satisfactory but the customers are not?
In the case that a consumer is unsatisfied with the goods or services provided by an SME, they must act promptly in order to act fair towards the supplier. In relation to goods, if it can be fixed, fix it. Otherwise, the supplier can either replace the item or refund the purchase price, and this is usually up to the supplier. Also, replacement goods are still covered by the CGA. In relation to services, the consumer's first point of call should be with the trader to fix the issues for free. However, if they fail to fix the problem, the consumer is able to cancel the contract or get someone else to remedy the problem and tell the original trader to cover the cost. If the item is not fixed within a reasonable time or is a failure of substantial character, the consumer may ask for a replacement or refund. In addition, the consumer is also able to apply for consequential loss, whether they reject the goods or not. However, the damage must be reasonably foreseeable. Also, once the defect is known, delay in taking action may mean loss of remedy.
One question that SMEs could have is whether it is possible to contract out of the CGA. The CGA applies even when there is agreement between the parties stating otherwise. To contract out of this is a breach of the Fair Trading Act. The exception to this, however, which is relevant for SMEs, is a business-to-business transaction. This is covered in Section 43 of the CGA. For this contracting out to be valid, there are requirements to be met. Both parties must be in trade, it must be in writing, and the terms must be fair and reasonable. What is reasonable is judged by the court. Overall, understanding the terms and conditions of the CGA is crucial from an SME business perspective. You need to understand what consumer guarantees are given and what obligations you have. This will allow you to avoid facing legal claims by unsatisfied consumers. An example of a practical consequence for a business who disregarded or was unaware of their obligations is the car dealership Vehicle Logistics Limited. They were fined $75,000 for misleading consumers about their rights, as they sold used vehicles without a guarantee or warranty. So what can be learned from a case like this? At the end of the day, suppliers shouldn't be trying to avoid their CGA obligations. As SMEs, you need to know what these obligations are and adhere to them. In line with this, if a customer has a valid complaint about a product or service, it is good practice to offer a replacement or refund where necessary to avoid a costly legal battle. To find out more information about the CGA or any other legislation in New Zealand, we recommend visiting these links. Thank you for listening to our presentation.